We will remain in this plenary session for keynote openings. It is my distinct honor to introduce today's first keynote speaker, full Professor Milenko Kreća, a visionary leader in the field of international public and criminal law. Professor Kreća is a former judge ad hoc of the International Court of Justice and European Court for Human Rights, former member of the Venice Commission and Permanent Court of Arbitration, president of National Branch of the International Law Association, member of Executive Council of the International Law Association from London, president of the Association of International Criminal Law in Serbia, and member of All Slavs Academy of Sciences and Art from Moscow. Professor Kreća will shed some light on decisions of the International Court of Justice in Gambia versus Myanmar and South Africa versus Israel cases as a new perspective of adjudication of crime of genocide.
I say a few words about the decisions of the International Court of Justice in two recent genocide cases, Gambia versus Myanmar and South Africa versus Israel. The importance of decision of the court in recent cases is in promotion of obligations erga omnes partes. As a matter of fact, the International Court of Justice, in his famous Barcelona traction judgment, said that essential distinction should be drawn between obligations of states towards international community as a whole, so-called obligations erga omnes, and obligations vis-à-vis other states take individually. This obiter dictum of the court produced strong influence on theory of international law, although as obiter dictum, it's not binding on states. It's incidental reasoning of the court, not connected with the subject matter of the dispute in Barcelona case. In these two cases, the court applied truncated conception of obligations erga omnes in terms of obligation erga omnes inter partes, meaning collective interest of the group of states or community interest. The essential meaning of obligations erga omnes partes, understood as secondary rules of international law, lies in the horizontal expansion of the jurisdiction of the court ratione personae based on the subject matter of the dispute without deviating from the principle of consent as a fundamental principle on which the International Court of Justice rests. These obligations deviate from the strict paradigm of bilateralism in the jurisdiction of the International Court of Justice, developed by analogy with the internal law, and as such expressing individual interest of international states within the proper construction of international community. This paradigm became too narrow with the growing interdependence of states, which is expressed inter alia in the emergence of group and collective values and interests shared by a number of states or all states in the international community. Novum in the decision of the court essentially refers to interpretation of its jurisdiction ratione personae as a primary form of its jurisdiction in terms of the common interest as superior one to a special interest of states, for, as the court said, if a special interest is required, in many situations, no state would be in position to make a claim. Thus, the court distanced itself from the traditional principle of parens patriae in the case of genocide as a crime under international law, in contrast to cases related, exempli causa, to diplomatic protection by state of nationality of injured state. The court dissenting opinion, in fact, dissenting from parens patriae principle, is not completely new in its jurisprudence. It's discreetly announced in the judgment of the court in the so-called Bosnia case, although in cautious and reserved way. Elements of the conception of obligation erga omnes partes in terms of horizontal extension of the jurisdiction of the court, ratione personae, are also incorporated in Articles 62 and 63 of the Statute of the Court, enabling third states to participate in the proceeding before it. As such, intervention is an exception to the court's bilateralism. Moreover, both articles confer the right to intervene using the term any state, meaning that it is not necessary that the state seeking to intervene under either of these provisions should be a party to the statute, if it fulfilled conditions provided in Article 35, paragraph 2 of the statute. Obligations erga omnes partes has as one of its effect elimination of the difference between two forms of intervention. Intervention of a third state on the basis of Article 62 of the statute, or intervention upon the permission of the court, so-called discretionary intervention, equalizing these two forms of intervention. Of course, the conception of obligations erga omnes partes is not free of difficulties and even controversies. But these difficulties and controversies are not inherent to the very notion of the obligations, are not the element of its own substance, but resulted from the institutional shortcomings of the international law, as law in one decentralized international community. That's in short the presentation of the judgment of the court in these two cases, which in my, and not only my opinion, would have impact on future adjudication of the crime of genocide in international law. That's, of course, a matter of high importance. Thank you so much for your attention.